General tranquility. It is time for the Remissions Act. It is time to correct the Supreme Court on the powers of presidential pardons. Under Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states, when called into the actual service of the United States. He may require the opinion, in writing, of the principal officer in each of the executive departments, upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. It is the Supreme Court that granted the right to the President of remissions, forgiveness of fines, penalties, and forfeitures. There needs to be an amendment that specifically states that the President cannot grant remissions. If new evidence exists showing that they are innocent, they can appeal for remissions to be given. If no evidence exists, then they have gotten the pardon the Constitution grants, even without any proof of innocence. Any lawyer shall take the case for a percentage if there is evidence to show the court of their innocence, especially given that proof of innocence also means suing for wrongful conviction. The Remissions Act, an amendment. Section 1. The President shall have no power to grant remissions of fines, penalties, and forfeitures to anyone, including those the President has pardoned. Section 2. Congress shall have the power to grant remissions of fines, penalties, and forfeitures to those pardoned by the President, with a 2/3 vote of both houses. If the person is innocent, they should win that vote. There, short and sweet. The innocent can get remissions in two ways: congressional action and the courts. If they are innocent, they can appeal to the court, then higher courts, until they hit the U.S. Supreme Court. Background and related information on power to grant reprieves and pardons. 1. The U.S. Supreme Court has interpreted this language to include the power to grant many different forms of clemency, generally less sweeping than a full pardon, including not only pardons, but also conditional pardons, commutations of sentence, conditional commutations of sentence, remissions of fines, forfeitures, and other criminal financial penalties, respites and reprieves, and amnesties. The pardon power of the President applies only to convictions under federal law. Additionally, the power extends to military court-martial cases, as well as convictions in the Superior Court of the District of Columbia. Almost all pardon petitions are addressed to the President, who grants or denies the A-1966 U.S. Clemency Certificate request. In some cases, the President will, of their own accord, issue a pardon. Since the 19th century, applications for pardons have been referred for review and non-binding recommendation by the Office of the Pardon Attorney, an official of the United States Department of Justice. 2. These terms differ subtly from country to country, but generally, clemency is a general concept of amelioration of penalties, especially by action of executive officials. The forms it may take include the following: amnesty, a pardon applied to a group of people rather than an individual. President Jimmy Carter offered amnesty to anyone who had evaded the draft. Weapon amnesties are often granted so that people can hand in weapons to the police without any legal questions being asked as to where they obtained them, why they had them, etc. After a civil war, a mass amnesty may be granted to absolve all participants of guilt and move on. Amnesties are typically applied in advance of any prosecution for the crime. Commutation, substituting the imposed penalty for a crime with a lesser penalty, whilst still remaining guilty of the original crime. E.g., someone who is guilty of murder may have their sentence commuted to life imprisonment rather than death, or the term of imprisonment may be reduced. Remission, complete or partial cancellation of the penalty, while still being considered guilty of said crime, i.e., reduced penalty. This should not be confused with what is known in the United States as remission of remand, in which a case is sent back to a lower court from which it was appealed, with instructions as to what further proceedings should be held. Reprieve, temporary postponement of a punishment, usually so that the accused can mount an appeal, especially if he or she has been sentenced to death. Respite, the delay of an ordered sentence, or the act of temporarily imposing a lesser sentence upon the convicted, whilst further investigation, action, or appeals can be conducted. Parole is the provisional early release of a prisoner who agrees to abide by imposed behavioral conditions, generally including periodic check-ins with parole officers. Failure to comply with the terms of early release may result in reincarceration. Expungement, the process by which the record of a criminal conviction is destroyed or sealed from the official repository, thus removing any traces of guilt or conviction. Immunity from prosecution. A prosecutor may grant immunity, usually to a witness, in exchange for testimony or production of other evidence. The prosecutor conditionally agrees not to prosecute a crime that the witness might have committed in exchange for said evidence. For example, a car thief who witnesses a murder might be granted immunity for his crime as an inducement to identify and perhaps to truthfully testify against the murderer. Some criminals who testify for the prosecution may be offered immunity from prosecution for their own crimes.